You know, if you look at the Constitution,
Okay.
the Constitution has what you call clauses which are justiciable.
Right.
And we have non-justiciable clauses. And those non-justiciable clauses are mostly under Chapter 6, from, I believe, Article 34 all the way to Article 41, right? Then we have entrenched provisions, and we also have non-entrenched provisions. Under the judiciary, Article 125, Article 127, 145, and 146 are all entrenched provisions. Now, what it tells you is that the makers of the Constitution have elevated those entrenched provisions to a different level. You understand? So it's not even easy for you to just say that you are going to amend the Constitution by parliamentary, process. You need to get the general, public by virtue of a referendum. So the reason I'm coming to this point is that if you look at the process that we are going through, it leads to the emergence of a new Chief Justice. And if a Chief Justice is in office, the only way that you can get the Chief Justice out in the Constitution is by resort to Article 146. Article 146 provides that the only way that you can get a Justice of the Superior Court or the Chief Justice out of office is only three: stated misbehavior, incompetence, and then inability to perform the functions by infirmity of body or mind. Now, our argument is that if you go ahead to vet Justice Paul Baffoe-Bonnie, and then he's given his instrument of office, he takes over as the Chief Justice, substantive Chief Justice, and then these cases of Justice Torkornoo terminate in her favor, what's going to happen? We're going to have a very serious constitutional nuclear meltdown. Because the only way that you can remove Justice Baffoe-Bonnie at that time is by resort to Article 146. You have to establish that he's incompetent. You must establish that he has done something, you have stated misbehavior or infirmity of body and mind. So in order for us not to get to this stage, why don't we give, enough room for Justice Torkornoo to exhaust all her remedies? She exhausts the remedies while we're in a hurry. There's no bottleneck anywhere. The system is performing, the system is running. Justice Paul Baffoe-Bonnie as acting Chief Justice is in full control of the judicial arm of government. And so nobody is saying anything. We're just, in fact, the operation of Article 144.1 that, my good friend Honorable Edem Agbana is raising, it's not something that we the minority will call into question. Our only issue is on the when Parliament should do that not whether Parliament has capacity to do it. Because it's a constitutional imperative. Parliament must do it. But we are saying that why don't we, hold on for a while and allow the process, at the courts to terminate. And the person who can make it happen is the acting Chief Justice. To bring finality. And then we can have our lives back. And Justice Torkornoo can have, in fact, one of the issues that she brought to court, interestingly, is that all the petitions, the one that came from Yakubu Ayamga, the one that came from Daniel Ofori, and then that other NGO, all of them were petitions for the removal of Chief Justice. Each one of them, petitions for the removal of Chief Justice on stated grounds. None of them talks about petition for the removal of her as Chief Justice and Justice of the Supreme Court. So that is also an issue that she has brought before the court. She needs to be given finality. Because if you remove her as a Justice of the Supreme Court, that means that she loses all her pension. She loses everything that she has worked for 25 years and all in the public service. And so you need to be able to give her. This is not too hard to ask. You understand?
But Hassan, let me ask you this. Let me ask you this. If we encourage a situation where by the mere filing of a process in court, other arms of government are supposed to be stopped from performing their constitutionally mandated duty, wouldn't we create a chaotic situation? That's my first question. My second question is this. Gertrude Araba Kumsin, Torkornoo, sorry, I said Kumsin, Torkornoo, has been in court for several other issues. I mean, she has made all kinds of...
They are only interlocutory matters.
Yeah,
the inductions were the ones that were struck out.
No, Hassan, hold on. I'm saying that she's been in court for several reasons.
Yes.
Trying to get all kinds of hearings or all kinds of judgments in her favor. Now, the three which are before the courts.
The Supreme Court, yes.
One is with the High Court, one the Supreme Court, isn't it? Okay. Now, even if, let's even assume, without admitting, that the acting Chief Justice has sufficient powers, as you've been trying to argue this morning because he's the head of the administration, to say that, okay, bring the cases. Let's look into the cases today. As soon as the cases are heard and a ruling is given, Torkornoo says, and as some lawyers do, as soon as the case is heard, the following day, another one can be filed. What you lawyers call a legal strategy, right? Now, if it is the case that any time the case is filed before the court would have to hear the matter for as long as it has something to do with her before the vetting happens. If I'm Torkornoo, I can frustrate the court for 4 years. Sorry, I can frustrate the vetting for 4 years
now,
by filing processes in court, which is not actually, which is something that is not, which is as of right.
Let me
get the point.
Let me explain to you how.
If I want to abuse that process, I can.
Yes, you've used the appropriate word.
Okay.
When you go to the courts, sometimes people see the courts maybe as places where people can just go and file multiplicity of suits, but that's not how it works. You understand? When you bring an action in court against me, and I look at the rates, and it has nothing to do with me, it's frivolous, vexatious. In fact, those are the words in the CI 47, the rules of court. It's frivolous, vexatious, and it has no merit. I can, as we say in court, ex debito justicia, as the justice of the matter, applying for the court to strike it out right from the beginning. We call it in limine. Strike it out from the beginning. You understand?
Right.
Those remedies are provided. You get what I'm saying? Or if I filed something against you, and then you think that maybe what I filed is irrelevant, it doesn't have anything to do with me, I don't enter appearance. I enter conditional appearance and apply to the court to immediately strike out your claims. Okay. So if she comes in and she doesn't have a claim, or the matter is res judicata, you have brought it to courts and the courts have said that this is our decision, and then you are coming again, there is something called res judicata. If the case has to do with the same parties on the same issues, then the court will look at it and say that, look, you've come to this court already, and then they'll throw you out.
Okay.
Eja and Foliata and then Eja. There are a long line of cases which deal with these things. But you see, the point that we are saying is that nobody is saying that the intention of Justice Torkornoo is to drag this matter for as long as it takes, because you have not even listened to the matter to start with. Two cases by census, an NGO called Census. There's one by Honorable Vincent Asafwa.
Okay.
And then there's one by the Chief Justice, Justice Torkornoo herself at the Supreme Court.
Okay.
The three other ones had to do with the work of the committee. He says that you didn't give me a hearing. You understand? You didn't give me a hearing. So if you didn't give me a hearing, there's an opportunity, and it becomes an administrative panel.
Okay.
The work that the committee did is the work of an administrative panel.
Okay.
And so they are amenable to judicial review powers. And if you are going to ask for judicial review, of an administrative panel work, the best place to go is the High Court. So if I go to the High Court and I don't get judgment, I have every right to go on appeal.
Okay.
To the Court of Appeal and the Supreme Court. That's one, you can't do anything about it.
All right.
But you can't go and be filing multiplicity of suits in court on the same subject matter.
Right.
That one, that's abuse of the court process.
Okay.
And costs may be awarded against you in punitive terms, so that you don't repeat any of those things. But all in all, allow Justice Torkornoo an opportunity. Give her her day in court.
All right.
That's what we are saying.
Okay. Eric,
that's what we are saying. Give her her day in court.
I think that, Moro, we need
all of us deserve that.
Because we need to move on because we have established that no provision of Article 146 or any aspect of the Constitution was breached in her removal.
That's the thing. They should just go and say it in court.
It was not breached in her removal. That must be stated. Number two, President Mahama and the government did not breach any provision in the appointment of Justice Baffoe-Bonnie. 3, Parliament did not breach any provision of the Constitution or our standing orders in the vetting process of Justice Baffoe-Bonnie. If it is the case that the former Chief Justice is now fighting to remain a justice of the court, there are many schools of thought on that as to whether or not, for example, if you are removed as the Chief Justice, you should remain a justice of the court and what have you. Okay. I have no comment on that.
Right.
The most important thing for me as a legislator is that no provision of our Constitution was breached in her removal. Neither was any provision of the Constitution breached in appointing a new Chief Justice. Let's move on.
Okay.
Let's see how we can build a strong judiciary. A judiciary that the people of Ghana will have confidence in. Last year, 2024, there was an Afrobarometer report that says that 9 out of 10 Ghanaians did not have confidence in the judiciary. This is a judiciary that some people perceive that even with goats, with yam, tubers of yam, you can influence judicial decisions. Let us see how, under the incoming Chief Justice, we rebuild that confidence in the judiciary. That should be the matter of concern to us, not whether an individual. I think that we need to move on.
So speaking about